Welcome, I'm Russell Alexander. I've been a lawyer with the team here at Russell Alexander Collaborative Family Lawyers for over 20 years. We help families going through separation and divorce. For valid marriage contracts, spouses must disclose existence, but not necessarily the value of assets. In an interesting recent case, the court reflected on the nature of the financial disclosure that divorcing spouses must give each other and concluded that there is a distinction between having to disclose the existence of an asset and having to disclose its value. The spouses started dating in September of 2011. At that time, the wife owned and lived in a home on a street called Grey Owl Run that had been purchased in 2004. She had lived there during a prior marriage and divorced from another man. When she and the husband got married in 2012, the husband moved into the Grey Owl Run property with her. He brought no assets into the marriage himself. The couple entered into a marriage contract in 2016. They ultimately separated in 2019. At which point the property was the sole asset in dispute between them. The validity of the marriage contract was a key component of this dispute, because under the wording, the property and any increase in its equity would be excluded from equalization. This naturally worked in the wife's favor and precluded the husband from claiming any legal interest, present, future, vested, or contingent in the property. As the court explained, the terms of the marriage contract confirm that the husband did not have an interest in the property, despite the fact it became the matrimonial home within the meaning of the Family Law Act. The marriage contract expressly provided that the Grey Owl property was to be excluded from the division of property equalization calculation or other method whatsoever in the event the parties separated. The husband asked the court to set aside the marriage contract. He conceded having signed it in 2016 and obviously knew about the property because he was living there at the time. However, his complaint focused on the fact that the wife had made no financial disclosure of the property's value, which had increased significantly since 2004. The wife was allowed to entirely exempt the property from equalization. By extension, any growth of the equity would also be exempted. The court was asked to invalidate the contract, freeing way for the husband to share in both. If you're enjoying this video and find it helpful or interesting, please give us a thumbs up or a comment below. The court reviewed the facts, and the husband had independent legal advice at the time of the marriage contract was signed, and it contained an expressed acknowledgement. He read it, understood it, his respective rights and obligations, and found the agreement to be fair and reasonable. He freely admitted to signing it voluntarily without being coerced. The court accordingly rejected this argument as to the lack of ILA, independent legal advice, noting that the husband did not produce any evidence beyond his bare allegations. Next, the Family Law Act did permit these spouses to agree on their respective rights under a marriage or on separation, including property division. The court could set aside their marriage agreement if it found one of several specified circumstances was in play, including a failure by the wife to disclose her assets. The burden of proof for setting aside the agreement was on the person seeking to set it aside, in this case, the husband. In assessing the wife's level of disclosure, the court made an important distinction. In order to meet the requirements for upholding a marriage contract, the wife must indeed have adequately disclosed her assets. However, this did not necessarily mean she had to disclose the value of an asset the husband knew or ought to have known about, in this case, the property. This remained true even if the property had gone up in value. The husband certainly knew of the wife's ownership of the property, since he had lived there with her. He could have asked her for the valuation information he needed, or could have taken steps to ascertain it himself. He was not entitled to enter into a marriage contract knowing beforehand that there were certain shortcomings in disclosure, and then later try to set aside the agreement by relying on those same shortcomings of his own failure to ask obvious questions. In the end, the court declined to set aside the marriage contract, concluding the spouse's mutual intent at the time of signing was to allow the wife to preserve her interest in the property at the date of marriage. You can learn more about this case and read the full article in the link we've provided below. Once again, please leave your thoughts and comments below if you liked this video and found it helpful. Please give us a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.